Mr. Bob?
Thank you, Your Honor. May it please the court. I represent Marjorie Taylor Greene, Member of Congress of the United States, in this hearing. And Your Honor, this is a court of law. This is not a political candidate debate. This is not a place for political hyperbole. It is not a place for political smear. It's a court of law. And what we've just heard, there was not a word about the law. What does Section 3 of the 14th Amendment mean? What does the word insurrection mean? What does the word engage mean? Not a word. There was not a word about the First Amendment that prevents normal political speech and a hyperbole from being used against someone. Not a word. They think they're in the wrong place. Well, I plan to talk about the law. What does this mean? This very serious charge that has very broad ramifications to the rights of Representative Greene, the voters in her district, and our democracy. First, the right to vote is at stake, right here, right now, because they want to deny the right to vote to the thousands of people in the 14th District of Georgia by having Greene removed from the ballot. Those voters have a right to vote for the candidate of their choosing, and they have a right to have their vote counted. Now, the primary is May 24th. Absentee ballots have already been printed. They will be mailed on May the 2nd, and early voting starts on May the 7th. And what is their hope is that there'll be a decision by the Secretary of State right before the primary, where she is immediately struck from the ballot. And those people that go into the polling place cannot vote for their candidate of their choice. Because by utilizing this procedure, the substantial constitutional and federal law violations that this candidacy challenge presents cannot be decided by this court. Unlike civil court or criminal court, which will always prioritize deciding issues of that magnitude before being subject to a trial, before being penalized by disqualification, and before the irreparable harm that will occur if that occurs. But that's the nature of the procedure. When can Representative Greene raise her constitutional defenses, like the evidence you are presenting violates the First Amendment to the Constitution? When are we going to be able to litigate that question? In state court. After she's disqualified, after she's stripped from the ballot, maybe after the primary occurs and she loses, well, nobody can vote for her, and obviously loses it. Well, whoop-de-ding. Okay? How do we recover from that? How do we go back from that? These are irrevocable. This is harm to the voters and to the candidate. Now, second, our democracy is at stake. It should be the voters, not government employees, public officials, judges, and lawyers who decide our elections. Voters have a right to vote for the candidate of their choice unless there is very compelling legal, not rhetorical, justification for that. Third, and which is not present here. Third, fundamentally, First Amendment rights are at stake. not only the right to vote, as I've mentioned, or the right to run for office, but also the challengers will try to use the First Amendment protected political speech of Representative Greene as evidence of, quote, engaging in an insurrection or rebellion. That's unconstitutional and should not be allowed. And finally, the charge not only triggers disqualification, but is a serious federal criminal offense that she is being charged with. Now, this is a very serious matter, and the decision should be based on admissible evidence under the rules. We recognize that you have greater latitude than that, but the charges, the seriousness of the charges, we think warrant that adherence and faithful application of the law, and we expect that you will do that. Now, procedure. Georgia law, and here I am talking about the law. Georgia law 21-2-5 permits a candidate challenge under two circumstances. One, a candidate is not qualified to be a candidate, all right? And number two is a candidate is not qualified to take office. Of course, these are different conceptually and different in their application. So a claim under Section 3 of the 14th Amendment has to do with your ability to take office, because it doesn't address candidacy in any way. It's the ability of a representative in this case to take office because she has sworn the oath of office, engaged in insurrection or rebellion. Congress has not given her amnesty. And finally, when she presents herself to take the oath of office, she could be challenged, which we think is the exclusive constitutional right of Congress, not state officials, to decide whether or not she is eligible at that time to take office. So we're not dealing with a candidacy disqualification, we're dealing with a alleged take office qualification. Now, unfortunately, as I mentioned, many of these issues cannot be decided by this court, even though you might make recommendations to the Secretary of State on the matter. And we have fully briefed this already in our motion to dismiss and to stay the proceedings. The constitutional claims, the federal law claims, the protections of the First Amendment, speech and debate, and what these words in Section 3 mean. So let's look at that. We admitted evidence is R2, which is the 14th Amendment, and it includes, of course, Section 3. And Section 3 provides that no person shall be a senator or representative in Congress, et cetera, et cetera, et cetera, who, having previously taken an oath as a member of Congress or an officer of the United States to support the Constitution, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof. So there's a sequence. You have to have originally taken the oath, you have to then engage, and then you are disqualified, and Congress can determine that you're disqualified for having done that, from taking a subsequent oath, and therefore cannot assume your position as a member of Congress. And then furthermore, but Congress may, by a vote of 2/3 of each house, remove such disability. And of course, that's the various amnesty acts that have been adopted or could be adopted by Congress. Now, this provision, as I mentioned, makes it clear this is about eligibility on January 3rd, 2023. Not today, not tomorrow, but eligibility when she presents herself as a re-elected member of Congress. She could be excluded under the exclusive power of Congress to judge the qualifications of its members. That's where these people should be. In Congress, explaining why she, once she is re-elected, is disqualified from taking her seat. Now, it makes clear is that in her case, she took the office for the first time, and these are in our stipulated facts, right? On January the 3rd. That's the first time. And so she would have had to engage in insurrection or rebellion after January 3rd. In other words, under the Constitution, prior to January 3rd, she could have done it under the law. Now, it's preposterous that she would even consider it. She reveres the United States Constitution. But the way the statute or the constitutional provision is set up, she would have to have engaged after. So evidence of anything she did prior to January 3rd is just completely irrelevant to the Section 3. Unless it is a direct admission of her intention to engage in insurrection or rebellion after January 3rd. Anything else she says is not only, it should be excluded because it doesn't fit the charge, right? But as I will soon demonstrate, it is protected by the First Amendment. Now here, words matter. And at every turn, the challengers mistake what the law is in their complaint. Obviously, they didn't discuss it here, but in their complaint. And calling something something doesn't make it something. Calling an orange an apple does not make the orange an apple. An orange has characteristics that are pre-established and are applied to determine whether the word apple applies. Here, the key phrases in Section 3 are themselves defined by the law. Now, they start off in misstating the law by saying that Representative Greene should be disqualified under Section 3. This is also called, by the way, the disqualification clause. Because she is someone who, quote, aided and engaged in an insurrection, end of quote. Complaint, page 1. Aided and engaged. Where is that in Section 3? It says, engaged in insurrection or rebellion, or gave aid or comfort to the enemies thereof. There's no aided and engaged in this. In this statute. Now, each of those phrases, engaged in insurrection or rebellion, that phrase, and its or accompanying phrase, gives aid or comfort to the enemies thereof. Each of those have special meaning. Engage is an act. It is a direct and overt act of insurrection. It is about, as one commentator said, domestic war. That's what engaged in insurrection or rebellion is about. The or, giving aid or comfort to the enemies thereof, as the same commentator said, is about foreign wars. Each of these phrases have been used several times in federal law and have come to gain particular meaning. They're words of art. So you can't take aid out of the second part about foreign wars and add it to the first part that is about domestic wars. That defies the rules of construction. It flaunts the technical and meaning of those phrases, of those words. So what is engage and what does it mean? Well, engage connotes conduct, a direct overt act of insurrection to overthrow the United States government. It is about things like, which the people who drafted this well understood, many of them were part of the victorious, thank the Lord, Union Army, and they knew what an insurrection or rebellion was. So it was taking up arms, voluntarily joining the Confederate Army. It was about working in the War Department for the Confederate government. It was about providing supplies and equipment and material for the people who were conducting the war. So these were direct overt acts of insurrection. Now, instead of looking to that, what we have already heard described as their evidence, and of course is well revealed in their complaint, they want to hold against her First Amendment protected speech. And here's a few examples. On page 19, quote, "The people will remember the patriots who stood for election integrity," end quote. That is supposed to be about an insurrection or engaging in an insurrection. Or they said, she's alleged to have said, quote, "Congress is the last line of defense from a stolen election," end of quote, on page 21. Isn't that quintessential political speech? Isn't that recognizing the role of Congress in certifying the electors? How could that be interpreted as an overt act to engage in insurrection or rebellion? Well, it can't be. And now, the question of voter fraud in the 2020 election is a quintessential example of political speech, legitimate political disagreements about what happened. Yeah, you know, the Supreme Court in Republican Party of Minnesota versus White, actually the first one I argued in the court, said that announcing views on disputed legal or political issues is at the core of the First Amendment. At the core. Now, this is disputed, no question. But to say that is an act of insurrection, it is a direct overt act of insurrection against the United States. When Representative Greene was an elected member of Congress who on January 6th had a constitutional duty and responsibility to be on the floor where she was to determine whether or not electoral votes from the states would be certified. Now, the First Amendment demands a very narrow test. I've already said and argued that engage connotes conduct. Right? But we can look to a much broader term that actually allows speech to be considered. And that is the Brandenburg case and the NAACP case, which we saw. And that is the word incitement. Now, incitement and engage are different words with different meanings. And in fact, you know that for sure, because there are federal statutes that say incite and then say engage in certain conduct. I mean, they're used as different words, right? Incitement, the Supreme Court has said, is speech, but the Supreme Court, because of First Amendment concerns, so that normal, everyday political speech will not be punished as they want to do, said that that speech must be, quote, directed to inciting or producing imminent lawless action, and that it is likely to incite or produce such action, end quote. That's on page 30 of our motion to dismiss. That is very restrictive, all right? But we know how restrictive it really is when we point out the statements that are made where people are claiming that is incitement, and the Supreme Court says, no, that's protected by the First Amendment. For instance, a Ku Klux Klan leader, quote, advocated the duty, necessity, and propriety of crime, sabotage, violence, or other unlawful methods of terrorism as a means of accomplishing industrial or political reform, end quote. And the Supreme Court said that is protected First Amendment speech. That is not incitement. There was also a statement by an NAACP official where he said, quote, if we catch any of you going in any of them racist stores, we're going to break your damn neck, end of quote. That was not incitement under the Brandenburg test. And we also have seen where a Vietnam War protester said, we are taking the street again, end of quote. And that was not incitement under the Brandenburg test. There is absolutely nothing that Representative Greene ever said that passes the Brandenburg test of incitement, and she can't even be held into account for incitement because this is engage, which requires conduct. Look, they knew what the words meant, and they chose the words that they were going to use. This was going to be a very narrow disqualification. Now, then they claim that Representative Greene promoted or organized the January 6th rally away from the Capitol, right, near the White House, and where some of the people at that rally went to the Capitol, and some of those attacked the Capitol. And I call it an attack. It was despicable for these people to do this, to attack the Capitol of the United States. So over 700 have been charged with crimes. If they are guilty, they should be convicted of those crimes. But you know, not a single one of them has been charged with engaging in insurrectionary rebellion, which is a federal criminal offense. Not one. Not one of the people that actually attacked the Capitol, assaulted police officers, broke in, and were there unlawfully. Well, the First Amendment right to assemble means that the right to assemble does not lose all constitutional protections merely because some members of that group may have participated in conduct or advocated doctrine that itself is not protected. So this was a quintessentially protected First Amendment right of assembly, and that some people left and went to the Capitol, some people attacked the Capitol. You can't hold the people who who organized a peaceful and constitutionally protected rally. They kind of hold that against them because that's what they did. Now, second, the challengers misstate the law regarding what is an insurrection or rebellion. They say it is, quote, to overthrow the government or obstruct its core functions, period, end quote. That's on page 32. Nowhere in any case does it say that insurrection includes obstruct its core functions. It certainly says overthrow the government, and certainly if that would occur, all of the functions would transfer to someone else, right? But they want to expand this so that, for instance, when a heckler in the House gallery stands up and heckles the Congress, the House, and they have to suspend that person is guilty of insurrection or rebellion because a core function has been obstructed. Look, this word is way more serious and narrow than what they say. Let me give you examples of what the either statutes or the courts, etc., have said. A domestic war, that is on page 20 of our submission motion to dismiss. A domestic war. Second, and that was the Attorney General in 1867. 2, combinations too powerful to be suppressed by ordinary course of judicial proceedings or by the marshal. That was temporarily so, apparently. I don't know. But even if it were, it wasn't, it was temporary and short-lived. Third, a rising so formidable as for the time being to defy the authority of the United States in such force that civil authorities are inadequate to put them down, and a considerable military force is needed to accomplish the result. Shays' Rebellion collapsed when the U.S. military showed up. And the military wasn't required here, even for the temporary attack. An armed insurrection too strong to be controlled by civil authorities. And then finally, the court in Allegheny City juxtaposed what an insurrection is and what an insurrection isn't. It says an insurrection is an organized and armed uprising against authority or operation of government. It is not, while crimes growing out of mob violence, which we certainly had on January 6th, however serious they may be, or however numerous the participants, are simply unlawful acts in disturbance of the peace, which do not threaten the stability of the government or the existence of political society. They're different, dramatically different. Now, we have stipulated that a group of people that did not include Representative Greene unlawfully entered the United States Capitol on January 6th. And they did. I mean, I say more than that about what happened, as I just have before your court, Your Honor, on behalf of Representative Greene.
Excuse me just a second.
Yes.
I apologize, Mr. Bob. Mr. Hamilton.
Sorry?
That's my guy who needs to help us with the sound. Excuse me just a second.
I hope he helps us with the temperature. He is the man.
Thank you very much. Apologize for the interruption.
No.
You know, if you're not under, we're far too old to deal with these issues. Far too old. Go ahead.
Yeah, and so we have willingly stipulated that people entered the Capitol unlawfully, and I say that more than that, more than just unlawfully. But significantly, they are willing to agree that those people that entered unlawfully did not include Representative Greene. So she did not engage on the attack on the Capitol. That, if there is conduct that meets the term engage, I mean, that if there is conduct that would ever meet the term engage, it would be breaking into the Capitol. That would be an engagement, certainly, an overt, direct overt act. And however, I think describing that as insurrection or rebellion is just political hyperbole and not under the Constitution. And that's what you have to engage in. Now, what you will see is pertinent evidence about what she did from us from January 3rd until the end of the day on January 6th. And you know, you will see that on January 3rd, and we've stipulated she was sworn in, she met with President Trump about making objections to certain states' electoral votes based upon evidence that she believed and others believed constituted sufficient voter fraud to overturn the election in those particular states. You will see that on January 6th, and of all the tweets and all the videos, we are presenting this video. This is during the moment when the attack on the Capitol was occurring. And she is in the Capitol in a dark hallway, and she says, first in the tweet accompanying the video, which they do quote in their complaint, "Be safe, be smart, stay peaceful, obey the laws. This is not a time for violence. This is a time to support President Trump and support election integrity," which they believe they were doing on the floor of the United States Congress. And then the video, so I urge you to remain calm. I urge you to have a peaceful protest. Make sure that everyone is safe and protected. And let's do this in a peaceful manner. This is not a time for violence. This is a time to support President Trump, support election integrity, and support this important process that we're going through in Congress where we're allowed to object. So this is very important, so I urge you to stay calm. Be the great American people that I know you are, and just know that we're in the fight for you. God bless everyone. Be careful, be safe, be smart, and obey the laws. A few days later, after the attack occurred, she said, "We," meaning members of Congress, "did not plan, cause, and denounce the January 6th attack." And then FBI Director Wray testifies before a committee of Congress. This is R5. "I was appalled, like you," he's addressing members of Congress, "at the violence and destruction that we saw that day. I was appalled that you," members of Congress, "our country's elected leaders, were victimized right here in the very halls of Congress." Representative Greene was a victim of this attack. Her life was in danger, she thought. She was scared and confused. Her children were frantic about what was going on and feared for her safety. That is not what a person who planned the attack would react. And you will see her reaction. And you will then hear her testimony. So, the attack on the U.S. Capitol, as despicable as it was not an insurrection or rebellion, and she certainly did not engage in it as understood under the law. That is what the evidence will prove, and why she should remain, among multiple other reasons, remain on the ballot. Thank you.